Everyone, welcome back to the channel. In today's video, we are going to discuss an important topic from penology, that is the Probation of Offenders Act 1958. First, let us understand the meaning and purpose of this particular act. The Probation of Offenders Act 1958 is a reformative law. The main aim of this act is to reform offenders instead of directly sending them to prison. The Act mainly focuses on first time offenders and minor offenders. The idea behind this law is that if a person commits a small mistake for the first time, sending him to jail may make him a hardened criminal because of the surroundings and environment in the jail. So instead of punishment, the law gives him a chance to improve his behavior and become a responsible person in society. Now let us discuss the important features of this act. The first feature is release of offenders after admonition under section 3. Under this provision, the court may release the offender after giving a warning instead of punishment. This is generally applicable in minor offenses where punishment is less than 2 years imprisonment or fine. The purpose is to give first time offenders an opportunity to reform without imprisonment. The second important feature is release on probation under section 4. Under this section, instead of sending the offender to prison, the court may release him on probation for a specific period. During this period, the offender must maintain good conduct and follow the conditions imposed by the court. The court also appoints a probation officer to observe the behavior of that offender and submit the reports. The probation period may extend up to 3 years. Another important feature is applicability to first time and young offenders. This act mainly benefits first time offenders and young persons involved in minor crimes. Especially offenders below 21 years of age are given an opportunity for reformation instead of imprisonment. Next feature is restriction on imprisonment of young offenders under section 6. If the offender is below 21 years of age and the offense is not punishable with life imprisonment, the court must first consider probation before giving imprisonment. This provision encourages courts to adopt a reformative approach for young offenders. Another important feature is the role of probation officers under section 14. Probation officers supervise and guide offenders during the probation period. They prepare reports regarding the offender's background, behavior, and rehabilitation progress. They also help offenders in counseling and social reintegration. Next, the Act does not apply to serious crimes. Offenders involved in offenses punishable with death or life imprisonment cannot claim the benefit of probation. Courts may also deny probation to habitual or dangerous criminals. Another important feature is that successful probationers may avoid a criminal record. If the offender successfully completes probation, he may not suffer the stigma of a criminal record. This helps in getting employment and living a normal social life for the offender. Now, let us understand the significance of this act. The act encourages reformation instead of punishment, as we said. It helps minor offenders return to society as better individuals. It also reduces overcrowding in prisons because minor offenders are not unnecessarily sent to jail. The act gives judicial discretion to courts to consider the nature of offense and possibility of reformation before giving punishment. It also promotes rehabilitation through counseling and guidance by probation officers. Overall, the Act reflects modern criminal justice principles which focus on corrective justice and second chances instead of strict punishment. However, there are some challenges in implementation. One major problem is lack of awareness about probation among people and even some judicial officers even. Another issue is shortage of trained probation officers in India. Sometimes courts hesitate to grant probation due to fear of repeat offenses. There is also lack of proper rehabilitation facilities and employment opportunities for probationers. Another issue is lack of uniform implementation across different states. Finally, let us conclude the Probation of Offenders Act 1958 is an important legislation which follows a human and reformative approach towards justice. It helps minor offenders reform themselves instead of becoming hardened criminals through imprisonment. But for effective implementation, India needs better awareness, more probation officers, stronger rehabilitation programs, and uniform application of this law across all states. Thank you.